This presentation deals with property taxes and/or property standards issues, bylaws, in the province of Ontario. Before we begin, I must give you a legal disclaimer that the information is current at the time of the production of this presentation. However, it is the viewer's responsibility to verify that the information is being applied correctly, and ultimately it is up to you how you use or misuse this information. This presentation is divided into several sections: legal maxims, formation of the government in Canada, primary legislation, your legal rights, secondary legislation, and a conclusion. There's a legal maxim which states court action could be heavy. So if some party, usually the municipality, has received some undeserved or unfair advantage over you by doing something illegal through the courts, then the court is obligated to correct this mistake. There is another legal maxim which says the outward actions, you're supposed to be responsible for your intent, okay? So if you notify the municipality through their council or through a meeting with some city official that what they're doing is breaking the law, and they continue to do it, then the above legal maxim would fall into place. They are presumed to intend to do the consequences, especially once they've been notified. There's also a provision within the Criminal Code of Canada which says ignorance of the law is no excuse. So if you notify the municipality of their wrongdoing and they continue to do it and try to force you into some obligation which is not correct, then you have tort damage claims that could be used against them in a court of law. There's another legal maxim that says no one except before God. This legal maxim denotes an accused person is entitled to make a plea of not guilty, and also that a witness is not obligated to give a response or to submit documents that would incriminate themselves. This is recognized in U.S. law as well as Canadian law. Okay, so you can refuse to state something which would incriminate you. There's another legal maxim that says the provisions of the law shall not depart or form the words of law, to which there is no departure. This maxim interprets the statute, which determines the intention of the legislature conveyed expressly or implied. So basically, if the statute says a certain thing, which more or less leads to a certain conclusion, that's the way it should be interpreted. The object is to determine the intention of the legislature conveyed or expressed, implied in the language used. So forget this legalese mumbo jumbo and some of these free man on the land cases where people say I'm not the capitalized name, or I didn't sign the document, it's on behalf of the capitalized name. Never go down that path. That path will lead you to several legal expenses and things that you don't want to have happen. Basically, refer to the statute or the act to get your remedy. Okay, intention to harm. This goes back to one of our earlier statements where I said the person's knowledge of the facts, once you notify them, if they continue to do it, then they're committing a crime. The person is to know their actions and appreciate what the outcome of those actions will be. So if you serve them notice and they choose to ignore it, you have every legal right to go after them in a competent court of law. There's a legal maxim that says earlier in time, stronger in law. This is very important because in any court case, if you can cite or reference, if we want to use that term, a case from a higher court, especially an older case from a higher court, the court is obligated to follow the same type of a judgment. This means that if you find a case that deals with property standards issues and the municipality was, say, charged for trespassing in, 1942, for trespassing on private property, if you can find that case, you can use that case and say, well, this municipality trespassed on my property, and here's a court case from a higher court, or at least an equal court, which states that they should be charged with trespassing. We will get into this more later. There's another legal maxim that says prima facie evidence, which means evidence on the face of it. So a lot of times a municipality will make false statements. And so if some false statements are done, then more than likely, or more than probable, the rest of the statements they will make are also incorrect. On the other hand, if you make a lot of statements which are correct and you verify most of them, and you can prove that everything you said is correct, then more than likely, evidence on the face of it, prima facie evidence, would indicate the rest of your story is also correct. This is why it's best to be honest when you're making testimony or swearing affidavits in court. Okay, legal maxim through lack of care. This again goes back to if we have the right to present our evidence, okay, and a court omits or willingly does not use your information and doesn't consider binding precedent cases, which means the older cases, or anything that you presented, or operates outside any statute when deciding the issue, then the case itself is void. Okay, here's another legal maxim. The legal doctrine that obligates the courts to follow historical cases, and I referenced that earlier. Okay, the standing of the decided does not disturb the claim. Basically, it's a legal maxim that says if there's an older case that states something similar to your case, or as close as we can get, the court is obligated to follow it. If it doesn't, the court case is void. There's another legal maxim that says the judge is to give a reason for the decision. Okay? So if a judge does not agree with you, they have to tell you why in a rational, logical explanation as to why they rendered a verdict against you or preferably for you. There's a legal maxim that says at the person. A lot of times when you present a case in a court, especially as a self-litigant, and the other party, if you've done your job correctly, hopefully cannot defend your case. So if they can't defend against what you've claimed, you should theoretically win. But a lot of times what they'll do with people that try to challenge the system is they'll reference a particular court case, and usually it's Meads versus Meads, which is an Alberta Queen's Bench court case, where the person that was trying to put this case through used a bunch of basically crap arguments. And what they do when you try to make your arguments based on the law is they will try to lump you in with these other people. So they will attack you. And this is called legal maxim at the person. They attack the person rather than attacking the actual substance of the case. And then here's another maxim, which again, damage in the sense of money lost, comfort, or services and health without an infringement of a legal right, injury to a legal right. This refers to an injury which is being suffered usually by you, the plaintiff, or maybe the defendant if you're defending yourself against a municipality, but there's no violation of a legal right of the person. So maybe they didn't violate the Constitution or they didn't violate some other law, but they did cause you harm. And injury does not necessarily mean a bleeding injury where you're, loss of limb or you lost a lot of blood. An injury is any sort of attack against you which you don't want. So if they infringe on your legal rights to the enjoyment of your property, as it would pertain to a property standards case, then that would be illegal, and you would have legal grounds to seek a remedy. There's another legal maxim that says an act does not make a man guilty unless there's a guilty intention. And this is actually to protect you, hopefully in this case, because if you don't intend to do something illegal and you do something which they frame as illegal, if you didn't have the intent to do that, then you have an excuse, basically a lawful excuse. If you believe you're operating within the confines of the current statutes or current laws, then how can you be guilty? And there are certain circumstances, which I could outline, where you have justification for violating a certain statute. For example, if you were bleeding and you had to get to the hospital and the speed limit said 40 kilometers an hour on your road, and you knew if you didn't get there in a short time you'd bleed to death, well, then exceed the speed limit, right? You're not guilty because there's a reason for it. No, it doesn't authorize you to drive recklessly or endanger the lives of other people, but you're not guilty because you have lawful excuse. Guilty act, okay, and this act basically proves criminal liability, which means if you intend to do harm, basically, then you have the right to a remedy. So if they intend to do you harm, steal your property, for example, it's the state of the mind. So obviously they intend to do you harm, then you have the right to a remedy. Fraud and justice never dwell together. This is a big one, guys. In this case, if they do something fraudulent, then there is no justice, and you have a right to a remedy against that. And as a simple matter, most cases that you bring in court are civil claims. There's a statute of limitations, either within the statute that you're dealing with, or there is a statute of limitations on everything except fraud. So if the municipality's done you wrong, or somebody's done you wrong with illegal activity, which is fraud, then of course you have a remedy to that. No justice if there's fraud, basically. Maxim, law or right does not arise from an injustice. So here again, this emphasizes that if the municipality, in this case, does something wrong, then there is no law, and they don't have a right to use that as sort of a defense or a way to make a claim. There is no wrong without a remedy. That's back to what you stated earlier. No man can take advantage of his own wrong. So if the municipality does something and they attempt to use the court as a way to convict you, and it's been wrong, proven wrong, and under statute, under precedent case law, under your legal rights or remedies, then they can't take advantage of it. The court has an obligation, as I said earlier, to fix it. You may have to go through several legal proceedings to get there, but they have a right to fix it, and they have a duty to fix it. The foundation is being removed. The superstructure falls. This basically means if they do everything illegal and improper, which is par for the course for many municipalities, especially the one where I happen to reside, in my experience, then they have no rights, because the foundation of their claim is crap. And so basically all the claims and everything fall to the ground. Now, if we get into the formation of government, the current government within Canada, the monarch is the foundation of our government. They a lot of times say, Regina versus so-and-so, or the Queen versus so-and-so. This is actually malarkey, because the Queen has nothing to do with legal matters in Canada, which means the court is committing fraud upon the public. However, we'll let them get away with it, because this fraud actually helps us out. Okay? Now, in a courtroom, we can see that coat of arms above the court in this case, and often it's in most courtrooms within the British realm. Canada is only one of the British realms. There's Australia, there's other places, England, for example. And this coat of arms is actually on some documents. And if we look at that coat of arms and we go back and look at the coat of arms of the government, which we'll get into later, you'll see they're one and the same. So when you cross the bar and you make a testimony in a court of law, then you're not bowing to the judge and don't cross the bar because you're giving the judge jurisdiction. None of that crap is real. And this is where this free man on the land garbage comes from, and usually does a lot more harm than good. But in this case, we have the crown, and this is the seal. So when the court people bow to the crown and we cross the bar, the judge is operating as an extension of the crown. This is going to help us. So if we look at the Act of Will and Mar, if we notice here, there's a coat of arms on the top of the document. This coat of arms was legally on most documents up till about the 1700s in court. And what this did was, at this time, they dissolved the old force system of government, and they developed, under an agreement with the people, the inhabitants at the time, the current situation or the current structure of our current government. And it goes back to 1688, so it's a fundamental primary legislation. Now, we got to remember that there's primary legislation and there's secondary legislation. Well, this primary legislation, it says here, it was set up by the Lords Spiritual, Temporal, and Commons, and conveyed in Westminster, and it carries on. So what this did was it actually formed the two houses of government, liberal and conservative, or call them whatever you want. That's the House of Commons. You've heard the House of Commons? Well, Lords Spiritual, Temporal, and Commons. So that's the creation of the House of Commons. Now, nothing can be done without receiving royal assent from the Crown, which means the three parties have to agree: Spiritual, Temporal, and the House of Commons. Well, the next thing that comes along in 1688 was they developed the Bill of Rights. And if we look at one specific part here, it says the subjects' rights. The Lords Spiritual, Temporal, and Commons, pursuant to the respective letters, assemble full and free in respect of the nation, taking their most serious consideration to the best means of attaining an ends, aforesaid though the first place in their ancestors in like cases have usually done for vindicating and asserting ancient rights and liberties declared. Okay, so they're recognizing your ancient rights and liberties. And then it also says they're dispensing of the powers, suspending laws, because they're replacing the old law with the new law. Late dispensing of powers, same thing. Ecclesiastical courts are illegal. Now, under here it says the levying of money for or to the use of the crown by pretense of prerogative without grant of parliament for longer time or manner the same shall be granted is illegal. Well, parliament is the monarch which created parliament, which is the two houses of government. So when the courts solicit funds on behalf of the crown, they should be doing it under parliament, not parliament. So parliament doesn't have, as they often say, immunity, because parliament has to operate within the grounds and the confines of parliament, which is the Bill of Rights, the Act of Will and Mar, which we covered earlier, and the Coronation Oath. And the Coronation Oath here in 1688 basically says all kings and queens thereafter are going to take a solemn oath. I'm not going to get into reading all of this because it would take too long. But then it carries on, and it was solidified even better. Okay? It says oath to be administered to future kings and queens. Okay? So that tells you that even though the monarch is back to 1688 when its creation, all future kings and queens in the realm of England shall take this oath. Okay? Now, it's kind of funny here if we look at the archbishop or bishops of the realm. So how are the bishops giving the queen or the king the authority to do this? Which we can get it into later at a different presentation. But this bringing forward of future kings and queens still applies today, because our court system in Canada today is still operating under this British realm. Now, if we go to the Act of Settlement, this solidifies everything. It says, wherein the laws of England are the birthright of the people thereof, and all kings and queens shall assent the throne of the realm ought to administer the government of the same according to the said laws of their offices, and ministers ought to serve respectively according to the same. And I skipped some parts. Then it says the laws and statutes of the realm securing the established religion and the rights and liberties of the people thereof, and all other laws and statutes of the same now in force may be ratified, confirmed the same by his majesty, by and with advice and consent of lords spiritual, temporal, and commons, by the authority of the same. So that's telling you that they have to do it with the agreement. Okay, it says ratified and confirmed by his majesty. So any law or statute, if we want to call it that, which does not receive royal assent is in fact void. There's nothing more to it. Now they also set up the demise of the Crown Act in 1702, which basically states that if there's a death or demise of his or her majesty, they have a certain time frame that they have to appoint somebody new. So that guarantees that even if the king and queen died from 1688, anybody else they bring forward, they have 6 months. But anybody else has to swear that oath. Now, when an officer of the court, being a judge or the court clerks or the lawyers, barristers, solicitors, they all swear an oath of allegiance to the crown. So therefore, their actions must recognize and try to preserve and protect your birthright. This doesn't happen very often. The military oath in Canada, okay, they will be faithful and bear allegiance to Her Majesty the Queen Elizabeth. So the military is supposed to protect your rights. If we do the police oath, it says the same thing. Okay? Be loyal to Canada and uphold the Constitution of Canada, and I will, to the best of my ability, preserve the peace and prevent offenses and discharge of other duties, and faithfully in accordance with the law. Well, the law is the primary legislation. We've already gone through that. Now, can the police ever enter private property? Because a lot of times what the municipality will do is they will attempt to bring the police to try and enforce their bylaw. Well, and actually the police cannot enter private property without authorization. That authorization comes from you. Because if they're supposed to preserve the peace and they let them on the property, they're not preserving the peace, so therefore they're not doing their duty. Now, a lot of times what they try to do is they hold public, supposed to be public, hearings, but they do it in private over Zoom. This is illegal. Okay? It says right here under section 135, subject to subsection 2, the rules of the court hearings are to be open to the public. Well, when they have these Zoom calls or these other private backdoor court hearings, that's outside the law. So if they're doing that, that's also a violation of the statute, which makes the whole court case void. Can you record your own court case? Many times a person is told that they are not allowed to record their own court case, but actually under section 136 sub 2 sub B, the Courts of Justice Act gives every citizen of Ontario or the solicitor the right to audio record their own court hearing for the purpose of supplementing their notes. Well, when you're in a court case, especially if you're not used to court, you may forget certain things that transpire, so by all means record your court case. Just do it so it doesn't obstruct the court proceedings. You know, don't have your phone ringing and big bell going off because you left your phone on because you're using it to record. Do it quietly. You're perfectly within your legal rights, provided you're only recording your own court case. That's the key. Now, you're not allowed, supposedly not allowed to take photographs, etc. at a court hearing, but there's nothing to prevent you from making handwritten notes or sketches in a court hearing. Okay, nothing prohibits a lawyer from acting in person or a journalist from making an audio recording of a court hearing. Because we're supposed to have open and free justice, and how is the people supposed to know the law and what's going on in the court if everything's being held in private? Now, section 137, a lot of times when you try to retrieve your documents from the court will refuse to give you a copy of your documents, and that's illegal too, because documents are to be open to the public. There's certain cases, if it was a matter of national security, or if there was a young offender, or if it's a family case, or there's some kind of trade secrets, then those would be sealed. But for every other circumstances, pretty much, Court cases are to be listed, and they're supposed to be in public. Can a court seal a case without cause? No. This again goes back to what I stated earlier, that unless it's a trade secret, or there's somebody in the witness protection program, or there's a young offender, or there's a family case and they don't want to disclose the name of all the family members, then they can in fact seal a court case, but otherwise no. And courts do it often. So be aware that if you're dealing with the municipality, they may in fact try to seal your court case, which is unlawful. Can a court limit my response? No. Now, if you're, wandering on and not making any sense and not presenting any real evidence, the court may get frustrated and tell you that, okay, we've heard enough, we're done. But very often they try to limit your hearing because they don't want you to divulge too much information which the public will then get aware of, and may cause other people to take legal action related to something similar. So a lot of times they try to shut you down so you can't present your evidence, which is illegal. That actually is fraud on the court, by the court, and makes your case void. Not voidable, void. Legal maxim: he who asserts must prove. Many times the municipality will try to assert they have certain rights and authority to do certain things. They may label your vehicle derelict, or they may say you can't have that dump truck parked in the front of your yard if you happen to, maybe you're in construction and you have a dump truck parked there. I know of a case in Belleville where the municipality tried to tell this gentleman that he couldn't have a dump truck. Meanwhile, that was part of his job. So I would argue that, well, if you don't want me to have a dump truck, means you don't want me to have a job, so I guess you don't want me to pay taxes either. So if you have a lawful excuse, no problem. But a lot of times they'll label your vehicle derelict, and they're not mechanics, they have no idea. So if the vehicle's not missing a bunch of parts, or, dismantled, and it's up on jacks, and axle's half out of it, tires are off it, if it looks like it's intact and it's in reasonable shape, they must prove it's derelict. A lot of times what they'll assert in many municipalities is that a vehicle that doesn't have plates on it is derelict. That is incorrect. Under Section 7.1 of the Highway Traffic Act, the municipality can't regulate the license and parking of motor vehicles related to having plates or stickers. And of course now we don't have stickers, but when the COVID pandemic was on, you couldn't get your stickers renewed even if you wanted to. Now there's a different section which we will get into later that shows you they don't have the right to regulate licensing and parking of motor vehicles anyway. The burden of proof lies on the plaintiff. So if the city asserts a certain thing, they must prove or show good cause that the claim is real in order for them to prevail. A lot of times this doesn't happen. Courts go along with the arguments of the municipality because they make money. For every case that they put through and can solicit funds from the public, of course they make a significant amount of money on that, which is also illegal. What can't be done directly can't be done indirectly is another maxim. Basically, if they can't get you one way and they try to get you another way in the court, that would be illegal. And I've given you the precedent court case. One making a contradictory statement is not to be heard. So if the city argues one thing and then they argue something different because you catch them in a lie, and then they argue something different, well, okay, this is obviously they don't have a case. So you have a right to tell the judge to dismiss the case. Okay, acting and consenting parties are liable to the same punishment. This means that if the municipality makes a bunch of claims and you prove them wrong and they were argued by their lawyer and you prove them wrong and they still continue to do this, then the lawyer is just as guilty as the municipality for making these false statements. Legal maxim: equity follows the law. You're the one that has equity in your property, and as such the municipality doesn't have the right to take your property from you. Equity trumps all, basically, in law. There's a legal maxim that says the judge does not answer to a question of fact. The jury do not answer to a question of law. The jury is the trier of facts. So if you want a fairer hearing, some have suggested that you ask for a jury trial or a trial by jury. Okay, and this, in a way, prevents the judge from just overruling you and, running muckshot over whatever your case is. Because otherwise, especially if you find yourself in a private hearing, which is of course unlawful, the judge may disregard several facts. This is also why, as I stated earlier, you should record your own court case. There's another legal maxim: equity looks upon that which which ought to have been done. So therefore, if a judge or a court makes a mistake, either through willful intent or neglect, the judge or the court has an obligation to correct their mistakes. And if they won't correct their mistakes, the case is void, especially if you can point out a number of mistakes. You may have to do what's called filing an appeal. We're not going to cover that today, but that may be a legal recourse. Or you may also want to take the judge or magistrate to court in their own private capacity, because if they operate outside the statutory requirements, they're no longer immune. So the courts in Ontario are protected by the Law Society of Ontario. But if they operate outside that framework, then they're no longer protected, and their insurance contract is void, whatever. You have a legal recourse to take them in their private capacity. Now, if you are smart and you go to their bond company, the company that holds their insurance, and you notify them of the potential claim, they will probably act on your behalf and say, you go back to the judge and say, hey, you better smarten up. There's a legal case here, and if we end up with a legal lawsuit because of you, we're going to take your bond away. We're going to take away your insurance policy. Now, all public officials have to have public liability insurance through some sort of a bond, which is an insurance. If you take that away from them, they can no longer work in public. So you can basically get a judge fired for misconduct. There's another legal maxim that says, act done by me against my will is not my act. So sometimes you're forced into signing a document which you don't want to, such as if you get pulled over by a police officer and he tells you to sign a traffic ticket, or if the city tells you, well, if you sign this, we'll leave you alone, or some other garbage. If it's done under an act under coercion or threat, then you have a right to say, I signed that under threat and duress, so it's not legally binding. Now, you might have a hard time proving this, so if you do have to sign a document under threat and duress, write right on the document, under threat and duress, or, I do not consent, something to that effect. There's a legal maxim says right to the point. A person's right to possession of property arises from a contractual obligation or a lease. So therefore you have a right to that property provided you can prove ownership. So in the case of if they want to take vehicles off your property, simply present the ownership and say, or tell them you have the ownership and you're not willing to relinquish it. If the municipality instructs a tow truck company or a flatbed operator to steal your vehicle anyway, legally they're not allowed to sell it. And legally they have to give you a receipt for it because they're taking property, so you have a right to a receipt. And you also have a right to know where that vehicle is being towed. You just simply take that receipt and your ownership down to wherever they towed your vehicle and tell them you want your vehicle back because the frickin' thing was stolen. Now, if we get into the actual municipal acts now, we're done with the legal maxims. If we look at the role of the chief building official, it's actually under section 1 sub 1.3. The chief building official has a duty in relation to sewer systems and also plumbing. So the municipality chief building official usually has employees or people that work under him, so they have no more authority than he does. And these people are called bylaw enforcement officers. And if they don't have any more authority than he does, then they can't regulate your private property. Remember, they've only got jurisdiction over sewer systems and that of plumbing. There's also a limitation on the municipality. It says nothing in this section relieves any person from a duty to comply with any part of this act or the building code. Right now we're dealing with this one act. So therefore, and it says doesn't affect the rights and duties of persons not mentioned. So if the building code says that there's this limitation, then obviously the chief building official must follow it. And if they're not following it, they're operating outside the statute, which means they no longer have immunity, which means you have a legal recourse to take them to court. Now it says the council of an upper tier municipality and of one or municipalities in the upper tier may enter into an agreement for the enforcement of the upper tier municipality. This basically gets into a system where if you have an upper tier and a lower tier, so you have a big city and you have a small city, and maybe one needs help from the other to try and enforce some section of an act. This is less common nowadays because a lot of the smaller municipalities were amalgamated into a larger municipality. For example, there's certain sections of Thurlow Ward in the province of Ontario which were private. They were separate from the city of Belleville. However, now under this amalgamation, which happened about 20 years ago, they're all in one. But there's a silver lining to that as well. We'll get into that later. Enforcement and the Board of Health. So under Section 3.1, if you remember our slide earlier, the chief building official said they had to get authority under Section 3. Well, this is 3.1, deals with the Board of Health or a planning board or conservation authority prescribed under the building code for the enforcement of provisions of this act and the building code related to sewer systems in the municipality. So if they're limited by Section 3.1 or Section 3, if we want to call it that, they don't have jurisdiction to regulate private property. Now it says provincial enforcement. Subject to Section 3.1, which is the one we just looked at, Ontario is responsible for the enforcement of this act in territory without municipal organization. Well, most municipalities are organized now. That's 1992. So if they want to somehow sort of argue that, okay, if the province has the ability to enforce it, then you're going to end up going to a provincial, some sort of a provincial court for the enforcement. Now it says bylaws and regulations. This is right in the building code. Section 7, sub 1, the council of a municipality or an upper tier municipality has entered into an agreement under subsection 3, sub 5, or a board of health prescribed for the purpose of Section 3.1 may pass a bylaw. A planning board prescribed for the purpose of Section 3.1 may pass a resolution. And then it goes on further to say the lieutenant governor and council may make the regulation applicable for matters for which the area of the municipality for upper municipality, board of health, planning board, conservation authority, or the province of Ontario respectively has jurisdiction for the enforcement of the act. So right there they're telling you it's limited to a planning board or a board of health. So again, their bylaw has no authority on private property. Now it says under Section 398 of the Municipal Act or Section 264 of the City of Toronto Act, they may be applied with necessary modifications to fees established under the local board. Again, we're dealing with local boards, right? We're not dealing with property standards people. And it says with the approval of the treasurer of the local municipality, the fees established under Section 1 sub C. Well, this again applies to fees added to a tax roll. But that is only applicable if you're under an agreement, because the Section 398 or 264 deal with special circumstances. We'll get into that later. Now, code of conduct. The principal authority, which in this case would be the chief building official, shall establish a code of conduct for the chief building official and its inspectors. So if the municipality does something wrong, if you look here under subsection 4, the principal authority shall ensure the code of conduct is brought to the attention of the public. So, okay, well, they don't do that. So if they neglect to do that, and you're involved in a court case, it's not slander because court cases are public. You have every right to bring the infractions out to the public because they're trying to bury them behind closed doors. Now, it says section 15.2. This is where they start to say they have the authority. Where a bylaw under section 15.1 in effect, an officer may, upon producing proper identification, enter upon a property at a reasonable time without a warrant for the purpose of doing an inspection of the property. And then it says they're supposed to present themselves and show why they're there and give their ID. Well, most of the time the municipal officers will trespass on property and they don't tell the owner. And then they just write up some garbage and they fire it off to you. And maybe in the case of Belleville, they threaten to take you to court without even telling you what the problem is, which is totally stupid because generally speaking, you try to mediate before litigate. In other words, you try to have a meeting before you go into legal litigation. So simple, mediate before litigate. And the contents of the order are supposed to be specific as to tell you exactly what the issue is, and so you have a chance to fix it. Because nobody wants to get involved in a court case before a judge or a magistrate if you could have simply, moved a 2x4 or something simple without going through all the expenses of litigation. Now, you're told that you're supposed to file an appeal with the board, so then therefore you would pay a fee to the municipality, which technically is a conflict of interest because if you're paying somebody who's saying you're guilty and then you're paying them to appeal it, you're technically paying your accuser. That totally doesn't make sense. Now, but it says upon the appeal, the committee has the powers and functions of the officer who made the order, and the committee's opinion would see right here. It says the committee's opinion would maintain the general interest and purpose of the bylaw and the official plan or policy statement. So they're telling you right there the committee's job is to enforce whatever the municipality wants. So are you going to get a fair hearing at this this meeting? No. And then it says they have the same duties and authority as the chief building official or the inspector. Then it says appeal to the court. The municipality, which the property is basically there, the decision under section 3.1 may appeal to the Superior Court of Justice by notifying the clerk. Well, if you read that, judge has the same authorities as the committee. So again, he or she is going to try to uphold whatever the municipality wants because it's in the best interest. So there's no way you're going to get a fair hearing. So that's total garbage. The conflict of interest again. Now it says that the municipality shall have a lien on the land for the amount spent on repairing and demolishing under subsection 1, and the amount shall have a priority lien status described under section 1. A lot of times what the municipality will do is they will put a lien on your property. However, as we're going to find out later within this presentation, the municipality doesn't have the authority to do that either. Okay, and also when they try to seek a claim against you, it says the monetary limit shall be administrative penalty and shall not be punitive. So it can't be added up or excessively heavy if you violated the bylaw. It's supposed to not exceed the amount reasonably required to promote compliance under bylaw under section 15.1 or an order under section 15.2 sub 2. Well, in order to comply, all they really have to do most times, if they do their job correctly, is tell the homeowner what the issue is, and the homeowner will more than likely try to work with them because nobody wants to be engaged in litigation. Now, if you do this and you do what you're asked for and do what you're told, then you have a right to ask for a certificate of compliance. And there's usually a small fee charged for it, of course, because the municipality is there to make money, make profit. But a lot of times you may pay for that fee and you may not get your certificate of compliance. So now the municipality is engaged in an act of unjust enrichment and deceptive practices. Now, the chief building official, it says right here, no person shall exercise the powers and perform the duties of the chief building official unless they have the qualifications. Well, that's fine, because the chief building official, as you recall, is only limited to plumbing and sewers. So if they turn around and they say that they're supposed to be here, and they label your vehicle derelict or your building, unsafe or something, ask that building inspector, bylaw enforcement officer, for their list of qualifications and certifications. They don't have it. A lot of times they just hire some flunky off the street. Okay, so you can, use that as a legal argument. Powers of the inspector, right here. Purpose of the inspection under the Act: the inspector may require production and inspection of documents, things including drawings, specifications relevant to the building or any part thereof. Well, why would an inspector need those type of authority unless it was to deal with planning and sewers and plumbing? See, planning, sewers, and plumbing. Otherwise, there's no need for that. And it says the inspector can remove documents. Well, if you're related to a property standards issue, there is no documents. But if they do it, they have to give you a receipt. Okay? Now, review of the inspection order. The chief building official may review and amend, rescind, or make an order made by an inspector. The chief building official may exercise any of the powers, perform any of the duties of the inspector. Well, remember, his job is limited to sewers and plumbing. Now, if you appeal to a court, a person who considers himself aggrieved by an order or decision made by the chief building official, you have a right to address this to the Superior Court of Justice within 20 days after the decision has been made. But many times what happens is the city will pass a bylaw without giving public notice, so you may not even know about it, and then when you find out, the 30-day time limit is gone, or 20-day time limit is gone. However, you have a right under the Limitation Act that states when you know that you were injured, which would be the time when you find out this, cuckoo bylaw went through, then you have a right to take it to court, Superior Court. Now, power of a judge. On appeal, the judge may affirm, rescind the order, and the action of the chief considers the chief building official, registered code agency, or inspector ought to take in accordance with this act or the regulation. And for the purpose of the judge may substitute his or opinion for that of the official agency of the inspector. So that's telling you that you have a right to go to the judge. But if you remember earlier when we talked, when you appealed something, they had the same duty and commitment as the chief building official or the inspector. This here now, you're going to the judge in order to get something fixed. Not specific to your order, but maybe specific to a certain bylaw. Now, if you further appeal, the party upon hearing to the Superior Court of Justice may, under Section 25, appeal the decision to the divisional court. So if you don't like what the chief building official did, you go to the committee meeting if you decide to go that route, and you don't get the order that you want because their best interest is not at heart, so they're not likely to work in your favor. You can go to the appeals court, basically, which is the Superior Court of Justice, and if you don't like that decision, you have the right to go to the divisional court. And the divisional court is at Osgo Hall in downtown Toronto. Irregardless of where you are in Ontario, that's more than likely where you'll end up. Now, there's immunity from action. This is important because no action or proceeding for damages shall go against a member of the building code or commission of the building material evaluation committee or anyone acting under their authority, a person in conducting an inquiry under Section 30, a chief building official, an inspector, an officer, done in good faith. This is important, the in good faith part, because if they don't operate in good faith and they commit perjury and they make false statements, they write their own complaint in order to solicit funds, anything like that is not done in good faith, so they're not immune. Subsection 1 does not relieve the Crown, and it says a municipality, an upper tier municipality, or a board of health, or a planning board, or a conservation authority of liability in respect to tort committed by their respective chief building official or inspector, to which would otherwise be subject in the Crown, municipality, upper tier municipality, board of health, planning board, conservation authority, liable for any such tort if it was not enacted. So therefore, they're telling you right there that you have a way out. You have recourse. And even if they took this out of the bylaw, it would make no difference, because a person is not allowed to operate outside the scope of the bylaw or the scope of the law and just commit whatever damages they like without a legal recourse. And you're not going after the Crown. In fact, you're asking the Crown to uphold its own primary legislation, which we went through earlier. Why would you sue the Crown? You're suing a company in London that has nothing to do with your legal matters. Now, the building code, section 37, it says right here, they have the authority to prescribe the traditional matters necessary for the regulation of sewer systems, which is back to what I said earlier, sewers and plumbing. A person includes a municipality. So when they refer to a person, they're referring to the municipality. You must realize, and you can look this up in a standard Oxford dictionary, the word includes is restrictive. As an example, if dinner, steak and potatoes, includes chocolate cake for dessert, well, how come I can't have lemon pie? Because it wasn't included. So when the person includes the municipality, when they talk about person, they're referring to the municipality. Right there. They're telling you it's right in the law. So they're not referring to you as the individual. Now, application to other acts. This section applies to all other acts and provisions and acts affecting related municipal matters unless the context otherwise requires. So they're telling you that the Municipal Act is to be used now in conjunction with the Building Code Act we covered earlier. So there's two acts that are involved. Actually, there's more than two, but we're going to go through these two. Now, the municipalities are created in the province of Ontario to be responsible and accountable governments in respect to matters within their jurisdiction. Well, that means they don't have carte blanche to do what they want, only within their jurisdiction. And each municipality is given powers and duties under this act and many other acts for the purpose of providing good government. So they're telling you right there, the act is to regulate the municipality. So if they operate outside that act, you have a legal recourse. Body corporate. The inhabitants of every municipality are to be incorporated as a body corporate. Well, that's not really true, because you're not an incorporation. You're not an incorporated company. But anyway, we'll just leave it at that. But that tells you, if you use this, that you can use the Municipal Act against the municipality because they're a corporation. However, a corporation can't produce anything. Okay? Application of the Act. The application is Not-for-Profit Corporations Act and the Corporations Information Act do not apply to the municipality. We're going to get into why in a minute. Regulations. The Lieutenant Governor General in Council, by regulation prescribed for the purpose of Section 2. So that, if you don't get a recourse, you can go to the Lieutenant Governor General in Council. And you can explain your situation and say, I'd like this fixed. Now, they can do something about it, or they can not do something about it. But it says right here, regulations. This is under the Municipal Act. For the local board, provisions of the Non-Profit Corporations Act, any modifications subject to provisions of the local board, and then definitions. Local board means local board other than a board of health, board management under the Fixing Long-Term Healthcare Act, a body corporate established under the Planning Act, or a municipal service board. So they're regulating right there that they don't, it doesn't say anything about private property. Now, powers exercised by council. The powers of municipality shall be exercised by its council. So when you go to a council meeting, right, they're supposed to fix this problem if you have a problem. So what I would do if it was me and I had a problem, I would say, when is the next council meeting? And I would bring this up at a council meeting. And when council meetings are open to the public, so therefore you can let this information out and say, well, if this is illegal, then why are you doing this? You have to fix this. Now, it says powers exercising by bylaw. A municipal power including, again, it's limited. A municipality's capacity, rights, and powers and privileges under Section 9 shall be exercised by bylaw, unless the municipality specifically authorizes otherwise. Subsections 1 to 3 apply to all municipal powers, whether conferred in this Act or otherwise. So it's telling you that this Municipal Act takes a certain priority regardless of what other act you're dealing with. Now, scope of making power. Without limiting the generality of subsections 1 and 2, a bylaw under sections 10 and 11, respecting a matter may, and it carries on. Now, so that tells you that the bylaw has to conform with section 9, as it stated earlier, and sections 10 and 11. So section 9, a municipality has the capacity, rights, powers, and duties and privileges of a natural person for the purpose of exercising its authority under this or any other act. Well, a person can't bind another person into a contract without their specific consent, by signature, by an act, or anything like that. A person can't compel another person to a contract, plain and simple. Section 10 and 11 says broad authority under a single-tier municipality. That's going to apply to most people. A single-tier municipality may provide any service or thing that the municipality considers necessary and desirable for the public. Well, okay, but bylaws are not to deal with anything public. And then it says bylaws. A single-tier municipality may pass a bylaw respecting the following matters. And it's telling you, governance and structures of the municipality, local boards, accountability, transparency of the municipality and its operation of local boards and their operations, financial management of the municipality and its local boards, public assets of the municipality acquired for the purpose of exercising its authority under this or any other act. Public assets is not your property. Public assets is things that are open to the public. Economic and social environmental well-being of the municipality, including, which is restricted, respecting climate change. Well, a municipality is not doing anything related to climate change. They're letting the chemtrail aircraft spray, and they have been spraying for over 20 years, and they've done nothing. It says health and safety and well-being of persons. Well, that's okay, but your private property's got nothing to do with that. Service and things the municipality is authorized to provide under subsection 1. Protection of persons and property, including consumer protection. So they're there to protect the consumer. Well, your private property has nothing to do with consumer. They can regulate animals. Well, that means the licensing of animals, because they don't want stray dogs and stuff running through the area in the municipality and then biting somebody. So they want a system for dog tags and that type of thing. Structures, and again, including fences and signs. So they can only regulate fences and signs and certain business licensing. They cannot regulate private property. That's section 10. Now, if we get to section 11 and we read through that one, it's basically the same as section 10. So a natural person can basically make a bylaw regulating the structure of the municipal and local boards, accountable transparency, financial management, public assets, economic, social development, health and safety and well-being, and services the municipality is authorized to provide, and protections of persons' property, including consumer protection. It says nothing about private property. Now, bylaws matters within a sphere jurisdiction. That's when two or more jurisdictions may work together. A highway, including parking and traffic on the highway. Well, on the highway is not on your private property, so they have no jurisdiction there. Transportation systems other than highways, so they might have a local bus service. Waste management, garbage collection, for example. Public utilities, if they have their own public utility, such as electrical service or gas service or whatever. Cultural parks, recreation and heritage. Drainage and flood control, except storm sewers. Structures, and again, limited, including fences and signs. Parking, except on highways. Animals, economic development services, and business licensing. Very similar to what it said in section 10 and 11. Now, if there's a conflict between a bylaw and a statute, a bylaw is without the effect to the extent it has a conflict with a provincial or federal act or regulation made under such an act or an instrument of the legislative nature, including, which again is limited, an order, license, or approval made or issued by or under a provincial or federal act or regulation. Now, it says restrictions affecting municipal powers, specific powers by law under general powers. It says if a municipality, not it does have, it says if a municipality has the power to pass a bylaw under sections 9, 10, and 11, and also under a specific provision of this or any other act, the power conferred, which means referenced by sections 9, 10, and 11, is subject to any procedural requirements, including conditions, approvals, and appeals that apply to the power and any limits on that power contained within a specific provision. So if they're limited by section 9, natural person, section 10 and 11, which pretty much read the same, they have no authority on private property. Plain and simple. Now, restriction affecting financial matters. Sections 9, 10, and 11 do not authorize the municipality to impose taxes. Well, wait a minute. I thought earlier they could impose taxes. Well, they can, only if there's an agreement. Otherwise, they can't impose taxes on your property. So all the taxes that a person has paid over the years is actually an act of fraud. It's right in the Municipal Act. It says they're not allowed to borrow or invest money or sell debt. It says they're not to incur debt without borrowing money for the purpose of obtaining long-term financing or any special capital undertaking. Enter into an agreement for the purpose of minimizing cost or financial risks associated with the incurring of debt. So if they hire a lawyer from a law firm, they are entering into an agreement and they're trying to minimize costs because they're thinking they're going to dump it on you. Well, that's minimizing cost or financial risk associated with the incurring of debt, because they have to pay that debt up front, or a pretty good chance of it. It also says they're not supposed to make a grant or a loan. So a lot of these municipalities are allowing casinos and stuff in their area. Well, isn't that making a grant or a loan? Take any other prescribed financial action. So right there, the municipality does not have the authority to deal with financial matters and incur any sort of a debt. And it's limited to sections 9, 10, and 11. In fact, if you read through the various acts, you're going to find most of their actions are limited by sections 9, 10, and 11. Now, specifically, if we deal with the Municipal Act, a municipality does not have the power to pass a bylaw establishing a system for permits on motor vehicles or trailers, as those terms are defined in the Highway Traffic Act, similar under section part 2 of that act. So the municipality can't tell you you have to have license plates or stickers or anything else on your vehicle. And I have a letter from the Ministry of Transportation that confirms that. Under section 63, the municipality can't pass a bylaw for prohibiting and regulating the placing, parking, or stopping, standing of an object or vehicle on or near a highway. And it can't do that unless it's parked right on the frickin' side of the road. The Highway Traffic Act limits them from doing this. So they can't tell you can't have a vehicle on your property. Demolition and conversion of residential properties. Here again, the municipality cannot regulate single dwelling units. So they can't tell you need a building permit. Section 99, we'll get into that later, but Section 99.1, a local municipality may prohibit the regulation and demolition of residential rental property, and may prohibit regulate the conversion of residential rental property. Well, your property is not residential and a rental. It has to be both. So most people, they have no right to regulate your property in building or demolition. Now, restriction. The municipality cannot prohibit or regulate the demolition or conversion of a residential rental property that contains less than 6 dwelling units. So if you have a mother-in-law suite, or you have a secondary apartment in the basement of your property, or maybe the upstairs of your property, and it's only for 1 unit, the municipality can't regulate it. And they can't regulate this conventional party that simply has his own residential property. They just can't do it. Okay? Despite Section 35 of the Building Code, in the event of the Building Code Act or regulation made under the Act, and a bylaw prohibiting the regulation and demolition and conversion of residential renter property. See, they don't have the authority. Subject to matters in different ways, the act and regulation under the act prevails by the bylaw is inoperative to the extent that the act or regulation of the bylaw within the same subject matter. So if the bylaw conflicts with an act or statute, basically they have no authority to the extent of the conflict. The municipality shall report okay, parking except on highways. Now, if we look at parking lot, without the limiting of sections 9, 10, and 11, a local municipality, in respect to land not owned or occupied by the municipality, is used for a parking lot, regulate or prohibit the parking or leaving of motor vehicles on that land without the consent of the owner of the land, or regulate or prohibit traffic on the land if a sign is erected at the entrance. So they have to enter into an agreement with somebody who has a parking lot, and then the municipality can regulate it. That's what that tells you. Other land, without limiting sections 9, 10, and 11, again, we're back to the same thing. A local municipality may regulate land not owned or occupied by the municipality, regulate or prohibit parking or leaving of motor vehicles without the consent of the owner of the land. So again, they have to enter into a contract with that land. Forfeiture of land, without limiting sections 9, 10, or 11, again, a municipality responsible for the enforcement of the Building Code Act may regulate in respect to the forfeiture, fortification, and protection elements applied to land in respect to the land, and prohibit stuff basically on the land. The land means land including, so it's restricted to buildings, mobile homes, mobile buildings, mobile structures, outbuilding, fences, erections, physical barriers, and any other structure of the land, or on or in any structure of the land. So they got no jurisdiction on the ground because land is restricted. Remember, land includes. Tree bylaw, subsection 4, without limiting to sections 9, 10, and 11, a local municipality may prohibit or regulate the destruction or injuring of trees. So again, they're limited by sections 9, 10, and 11. Power to establish a corporation, without limiting sections 9, 10, and 11, those sections authorize the municipality to do the following things: establish a corporation, authorize a person to act as an inspector, director, exercise the power of a corporation, acquire interest or guarantee securities by listed corporations, to exercise any power of the holder of securities. So again, they're operating as a corporation, right? But it's limited to section 10 and 11. Meetings, when they have these bylaws and they pass them, 239. It says right here, except as provided in the sections, all meetings shall be open to the public. And the only time that they are not open to the public, if you read the rest of the bylaw, or the rest of the act rather, is if it's a matter of security, protecting trade secrets and stuff like that. So if they have private meetings, those bylaws that are passed like that have no force and effect. Now, the interpretation of policies, right? We're trying to deal with policies, and they deal with the local board, local service, local housing corporation. So they don't deal with property, adoption of property. Municipalities shall adopt and maintain policies with respect to the following matters. Okay, this land, hiring of employees, relationship between members of council and office of employees, delegating powers, pregnancy leave. Local boards shall adopt and maintain policies in respect to the following matters. It's basically land and the hiring of employees. They don't have jurisdiction over property. You, however, have a right under Section 272 of the Municipal Act to quash a bylaw if it's not passed in good faith. Because it says here, a bylaw passed in good faith shall not be quashed or open to review in whole or in part by a court because of the unreasonableness or, basically stuff like that. Application to quash a bylaw. Upon application, any person to the Superior Court of Justice may quash a bylaw of a municipality whole or in part before it's for being illegal, basically. Bylaw includes an order of resolution. So if the city passes some order of resolution or bylaw that's illegal, you have a right to get rid of it. You also are not compelled to follow it anyway. Investigation by a judge. So you can ask for a judicial investigation. And you can request, you have a right to do that. You can request an inspection of this bylaw and state why you don't think it's valid. But you have to give legal reasons. Insurance. Remember I said earlier, if you take the person's bond, employee means a salaried officer or any person employed by the municipality or local board, and includes a member of the police force in the municipality. So if the police officers operate outside the provisions of the statute, you have a legal recourse against them. Powers for local boards. Again, it's dealing with local boards. It has nothing to do with you. The Municipal Act, bylaws. Remember, I said they can have a bylaw for a specific purpose, and that's for a specific service or something that you ask for. So when they do that, they have a right to put a levy or a penalty against taxes. But as a general rule, they can't charge taxes. We've already covered that. So if you're going to get a benefit or have them dig a ditch for you or something like that, then they have a right to charge you for the service. Now, debt, fee and charges imposed by a municipality or local board on a person constitute a debt of the person to the municipality or local board respectively, amount owing an added tax roll. A treasurer of the municipality, and upon the request of the upper tier municipality, if any, or the local board, area, and jurisdiction includes any part of the municipality, shall add fees and charges imposed by the municipality, upper tier municipality, or local board respectively, to a tax roll on the following property in local municipality. In the case of fees charged for supply of a service or thing to the property. Right there. So if they provide you some sort of a service or a thing to your property, they can charge for their services. Pretty straightforward. Okay? And it says in all other cases, the property for which the owners are responsible for paying the fees for charges. So you can do some of the work yourself. You can have the municipality do some of the work. You would be responsible for the half that you agreed to. They would be responsible for the half they agreed to. Now, public works bylaws to conform with the plan. This again gets into if the municipality is asked to provide a service. Right? There's not too many left here. Acquisition of lands for the in accordance with the provincial plan. So if the municipality wants to purchase the property, they can't just go around stealing it, obviously, because you have an equitable title. Okay, and it says they can purchase it for development in the future. Okay, well, that's fine. Who cares? And it says the acquired may be held, be sold, leased, or otherwise disposed of when no longer needed. Well, if the municipality owns it, of course they control it. Community improvement under section here. Section 28, community improvement means planning and replanning, design, redesign of a subdivision, clearance, or development. Again, that's community improvement. They have no right to do that on private property. And they can do it for affordable housing and under certain bylaw restrictions. Grant or loan between upper and lower tier municipality. Again, it doesn't allow them to do grants or loans to private companies. Condition of sale, etc. Registration of an agreement. So again, they need an agreement. Grants or loans for repairs. When a bylaw under section 15.1 of the building code is enforced, the municipality or the council may pass a bylaw providing making a grant or loan for the registered owners or assisted owners. Well, since when has the city ever loaned you any sort of money? So again, they're going to do this under the local planning board with a board of health or a conservation authority. They're not going to loan a private individual money. And right here, it tells you right there under subsection 15.2, sub 2. They may pay in whole or in part for the cost of the repairs required to be done for the cleaning, grading, leveling of lands on such terms and conditions as the council may prescribe. Well, that doesn't allow them to do that to you. And it says loans collected as taxes. The amount of a loan made under the bylaw passed under section together with interest rate to be determined by the council may be added by the clerk to the municipality to the collector's tax roll and collection of like matter in municipal taxes over a period fixed by the council, and such amount of interest shall be payment thereof, and being a lien charged upon land in respect to the loan which has been made. Yes, if they're into an agreement with a local board or a board of health or whatever, they can put a lien because they have equitable title in the property. But when they come to your property and place a lien on your property for some reason, for some service they never provided that you don't want, they can't put a lien on your property. That's a violation of the Land Titles Act. And now Section 33, dwelling unit means any property that is used and designed for the domestic establishment in which one or more persons may sleep and prepare and serve meals. Residential property means a building that consists of one or more dwelling units but does not include, okay, does not, so it's restricted, okay, accessory structures. So when they tax your property, if they wanted to do that, and they designate it as residential property, they can't do that either. Now, under Section 15.1 of the Building Code, they enforce the municipality or by the bylaw prescribed in the standard mates and occupants of property under any special act. So they have to do some sort of a special activity is enforced. The municipality and the council and local board may pass a bylaw designating an area which the municipality standards and maintenance occupied bylaw applies. So they're telling you right here, it doesn't apply everywhere, does it? Okay, it only applies when they enter into a contract. No person shall demolish or hold any part of residential property in the area of demolishing and control unless the person is the holder of a demolition permit issued by the council. Well, remember, they can't regulate residential property with less than 6 dwelling units. Residential rental property. So they can't do this to private property. Area designated in height, the authority to regulate under Section 4, Section 1. Decision of any court shall be deemed to have including the authority to regulate a minimum area parcel of land mentioned therein and then regulate any minimum maximum density. So again, it's to deal with economic planning and development. It's got nothing to do with your acquisition of non-conforming lands. The council may acquire land, building, structure used or erected for the purposes not conform to the bylaw passed under section. Any vacant land having frontage less than the prescribed amount. So it's to deal with acquiring property under a planning act. Well, they're not going after you under a planning act. It's usually building code bylaw enforcement, which is not even applicable to you under the Section 15 of the code because it's regulated by 9, 10, and 11. Now, if they do take your property or try to put a lien against your property, they're violating Section 45 of the Land Titles Act. I'll just leave it here for a sec. I'm not going to bother to read it. But it says includes an estate and interests of her majesty. Well, we have already went through the primary legislation that said that you can't do that on behalf of the Crown. So when they claim that it's on behalf of the Crown, that's a load of malarkey. I actually have a letter from the Queen that says that they have nothing to do with legal matters in Canada. So there is no act or lien placed on property that's subject to the Crown. Estate owned registered with specific title. The registered person of the first registered owner has qualified title. Same effect as a registered such person has absolute title. And if we look at at your land title document, you'll find out it's registered fee simple. And so therefore you have absolute title and ownership. The registered owner of land which is specified may apply to the land register to be registered as the owner of the title with an absolute title. Well, if you've been on your property more than 7 or 10 years, you have a right to request that. But most properties in Canada are in fact registered, or in Ontario, sorry, are registered as fee simple. So you have a right to request. Application be requested as absolute qualifier after 10 years. Estate first registered owner is leaseholder with a declaration of absolute title. So if you have absolute title, they can't put a lien against it unless they can show an equitable title. And unless they do some service for you, they have no equitable title. No title adverse possession. Despite any provisions of this Act, Real Property Limitations Act, or any other act, no title to any right or interest in the land registered under this Act may basically they can't take your title by the registered owner. Simple enough. This section does not prejudice against the person's registered first owner of land with possessionary title only. So they're telling you the Land Titles Act, even though if you don't have it registered properly, if you're still a first registered owner, you're in first lien position. Therefore, you have a right. Registration certificate, you get that from the Land Titles Office. Land subject to mortgage. Okay, so if there's a mortgage on your property, then the mortgage holder, bank, whoever it is, private lender, I don't care, has a right to put a lien, because it's an equitable lien against your property. And that's pretty tough. Remedy for a person wrongfully deprived of land. So if the municipality does place a lien on your property, you have a right under the Land Titles Act, Section 57, Sub 1, to make a claim for compensation and damages through fraud or error. Well, we've already seen now that municipality is operating in fraud if they put a lien against your property. And of course, you have a right to make an application under the Land Titles Assurance Fund. If that happens to the Director of Titles, you'd have to look that person up because it changes. However, if you can show the lien and show how it was unlawful and the violations I pointed out here, you may be able to get that lien lifted. If not, you will have to take the offending party to court, either in their private capacity, or take them and the corporation under their professional capacity, or take both. Estate fee transferable for consideration of land and absolute title. Okay, valuable consideration is an equitable title, an equitable claim, and under the equitable claim they have a right, but the municipality doesn't have an equitable claim. The bank does, but the municipality doesn't. Estate transferred for valuable consideration with qualified title. Again, the city didn't have equitable title. They didn't give you anything of valuable consideration. In fact, they probably hounded you, and technically they owe you. However, so they have no right under Section 88 of the Land Titles Act to put a lien against property. 89, estate transferee for valuable consideration with possessory title. Again, they have no equitable claim, so that would be another thing you could use against them. The only time a municipality may provide a service to you that you request is under Regulation 322/12. And it says there's nothing in this act authorizes a municipality to do local improvement on private property without the consent of the owner. So if you look that up, you'll find even more information. This presentation was brought to you by Denied Truth. We can be reached at the following address, and hope you found this information informative. If you make contact with us at the addresses shown here, I'm more than willing to try to assist anyone who wants to assert their rights with respect to private property. If you've been done wrong by some wrongdoing of the municipality and or its lawyers, fraud doesn't have an expiration date, so you will also have a remedy under that case as well. I hope that this information was informative, and I assure you to do your own research. Draft up, if you need to, draft up your story of what happened to you. Be as accurate as possible. Dates, times, people you talk to, things that happened. Don't try to stretch or fabricate or insinuate things that you can't prove, because all of this eventually will end up in an affidavit. And if you've made false statements, then those affidavits may be scrutinized. And if there's faults found within your statements, you've committed an act of perjury, and perjury will invalidate your claim. I'm just bringing that to your attention because the municipality very often enlists the services of a lawyer or an attorney who will make false statements in a court of law, and the judge will let them get away with it. And if you point it out, the judge is obligated to fix it. If the judge doesn't fix it, of course, then you have the obligation to assert your rights, probably in a higher court, possibly the divisional court, and possibly take legal action against the solicitor, lawyer, and or the judge. So there is a recourse. It's not an easy road, and I don't envy anyone that's going through this legal matter. I've gone through it, and I've done the research and presented this presentation in hopes to assist other people who may be in a similar situation. Many times a person doesn't know where to look, what laws to look for, what statutes to look for, and they're just lost. And most of the time, or every time, if you go to hire a lawyer, the lawyer has 3 obligations before you. They've taken an oath to the Crown, they've taken an oath to in this case, the Law Society of Ontario, and they're bound by the statute. And then they're bound to you. So they're not there as your advocate. They're there to solicit funds for the state, for the province. And as such, most times you'll find most lawyers, even if they are versed in litigation, municipal law, they won't take your case. So you're more or less on your own to do it. And if you have to appeal it again, you'll be on your own to do that as well. If you do find a lawyer that's willing to take the case and do what you want, remember that the oath binds them to the Crown and also to the province before you. So you may not receive the result you want. That's not to say every lawyer is bad, but it's going to be a tough road. You have to be well versed in your case and know your stuff inside out. With that said, I thank you for your time listening to this presentation. Hope you found it informative, and good luck. Thank you.